Hello and welcome to Quadcast, Quadrant Chambers weekly discussion forum. My name is Paul Downs. We are four barristers from London. That's me, Paul Downs, Poonam Mawani, Joe Sullivan and Claudia Wilmot-Smith. And every Thursday at 5 p.m. live on YouTube, we get together and talk about legal stuff. We argue, we have banter, and then at the end of it, the other three come around to my view and acknowledge me as being right. We also have a drink. I have, again this week, a cup of tea. And we invite you to join in. You can join in on YouTube chat function, or you can email us, quadcast@quadrantchambers.com. That's quadcast@quadrantchambers.com. And we will try and get to questions and comments that you have, if we possibly can, in the course of the programme. And this week is a special week because we have Professor Gerald Mcneil joining us as a guest later on in the programme to talk about contractual estoppel. But before we get to that, news. Joe, what's your news this week?
Well, I mean, continuing the theme of my football-based news, Liverpool, of course, as you'll know, won 5-0 this week against Atalanta. Hat-trick for Diego Jota, so that was pretty good.
You know, news is meant to be interesting, Joe.
I also love my news. I love how football fans teams' victories as their own.
Nobody cares. Nobody cares, Joe.
On the contrary, first hat trick for Liverpool, so we'll all be quite excited about that. Apart from that, I've basically just been wandering around trying to unsuccessfully to get my hair cut before lockdown. As we can see, that did not work. How about you, Claudia?
It was my birthday during one Quadcast episode, and Paul sent me a bottle of champagne. It was Poonam's birthday during a Quadcast episode, and Paul sent her a birthday cake and set her hair on fire. Paul's birthday was a couple of weeks ago, and we're all so self-involved, we just completely let it pass. So we actually got someone that Paul knows, I think it's Jessica Caroline Productions, arranged for some business cards to be made as a birthday present for Paul. So Paul, I think we have a present for you, which I can show you right now. So happy birthday for a couple of weeks ago. I'm sure that your practice will take off.
Bit of a trade description on that photo, Paul. When was that taken?
I'm not going to. I could respond to that. I'm not going to respond to that. Not yet, anyway. Thank you, Claudia. That's very kind of you.
Happy birthday, Paul. We live to please.
Poonam, you've got some news, haven't you?
Oh, come on. That's because I told you guys I have no news because it's lockdown and I'm bored and I'm upset. What I'm doing is just trying to avoid tripping over everything because I went mad and ordered a huge gazebo that would cover my entire garden with 2 open slides and masses of heaters and everything. And they arrived just as lockdown was announced. So I haven't opened a single box and they're all lying there. I'm trying to work out whether to return the whole lot unopened or open them all.
Poonam, not that news. You know what news I'm referring to, don't you?
What?
You look. You have confessed on this program that you have a bit of a fondness, shall we say? A soft spot for Rafa, don't you? For Rafa, you have a soft spot for Rafa, don't you?
Yeah.
And in the face of lockdown, even though you knew full well you're not supposed to mix households and all of that, I've got the photographic evidence. Here it is.
I wish it was me. You and Rafa.
What's your news, Paul?
What's my news? I've been working on an invention to help people in lockdown, people like Joe, because I think that what's going to happen is that we'll have the lockdown, but then they will, over the Christmas, they're going to close the schools and everything. So people like Joe are going to be faced with childcare issues. So I've come up with an invention to help people like this in the face of lockdown. So Joe, that's my gift to you.
I've already got one of those.
Right.
People.
Have we done everybody's news? I think we have, haven't we?
Yeah.
We are talking this week about contractual estoppel. Contractual estoppel, by way of introduction, is the idea that two parties to an agreement can agree anything they want, including a state of affairs that's completely fictitious. So, for example, you could agree with somebody that the earth was flat, which is all very well, of course, if the parties are signing that agreement.
Well, millions of viewers can't be wrong. A lot of people think the earth is flat, Paul.
Well,
We weren't supposed to get political.
me included. But anyway, but it's been pointed out that in certain contexts this could work in justice, and it crops up in banking and in certain other contexts. So there's a whole line of cases that deal with this, and they start with a case, I think in the 60s, called Low and Long Bank, Claudia, doesn't it? You're going to tell us about Low and Long Bank.
Yes, this is a case where a little old lady wanted to get a new car, and so she entered into a hire purchase agreement. An agent told her that the car that she was going to get specific
age for the old lady.
Ancient, very.
I mean, what are we talking?
Careful.
We're going to be very careful. I've read Low and Long Bank. I know how old that woman was. Would you like to say how old she is?
She was only 65. As a 65-year-old woman.
Sprightly.
A sprightly young widow entered into an agreement. An agent told her that she was going to get a perfect car. And so, having been told that her car would be perfect, she signed a contract stating that she had read and that she had understood the terms of the contract, that she had examined the car, it was in good order and condition, that she wasn't getting the car for any specific purpose. And when the car was eventually delivered, she signed a receipt saying she'd inspected it and she just thought it was just swell. I'm paraphrasing, but satisfactory condition.
Where was she from, this old lady? Somewhere in the deep south of America or something.
Mrs. Trump, wasn't it?
Yeah. She thought it was, she thought the car was really neat. And she hadn't inspected it. Spoiler alert, it was not in satisfactory condition. It was completely unroadworthy. It was a danger to herself and others. And she sued. Turned out that she has teeth. Fraudulent misrep, she said. Also breach of contract. She alleged that the hire purchase company had breached an implied term that it would be fit for purpose. And in response, the hire purchase company said, you signed this agreement saying you weren't getting it for any purpose. How were we to know that you were going to use this car to drive? Lord Justice Diplock said this was a bold submission, and it didn't really get very far. But there's also, interestingly, the sort of clause we're all actually probably pretty used to seeing in other kinds of agreement, where she had signed saying, I accept that I have inspected this car, I acknowledge that it's in good order and condition, was relied on by the hire purchase company. The court said they didn't see where they could go with this clause. I mean, Lord Diplock, not a thickie, said, I don't really understand the purpose of this clause. What's it trying to achieve? It can't have any contractual effect because she's just saying that she's done something which she hadn't done. That can't give rise to any sort of obligation. I mean, maybe there could be an estoppel, but you haven't got any of the facts to show reliance or any of this. So he told the hire purchase to go away and get her a nicer car. I made that up, but it was to that effect. But over 40 years later, we have a 2000 and something, I guess, about 2006 decision of Lord Justice Moore-Bick in PK and ANZ Bank. This is one of a ream of cases about GKOs, which were apparently very interesting investments in the 1997-98 period. And ANZ offered a product, structured dollar deposit with a return linked to a GKO with a specified maturity date. They didn't offer any ability to purchase or hold any interest in GKOs themselves because only specified institutions could hold them. But apparently the person who was marketing this didn't really understand the products, didn't really understand what GKOs were. And so when she called a Mr. Parawani, who was acting on behalf of PK to sell them, she made all kinds of misrepresentations because she didn't really know what she was talking about. And it was accepted that there had been misrepresentations. And when the Russian Central Bank defaulted on its obligations, rendering the investments worthless, Mr. Parawani, or PK, who was acting on behalf of, sued. The bank said, well, before he entered into this contract, he signed a statement saying, I have read this emerging markets risk disclosure statement, and I have read and understand the terms of the contract. And the Court of Appeals said if he'd even cursorily looked at the document, then he would have known that all of the representations were false. The true contract was very clear. It was buried in the small print. And so they said, basically, he signed saying that he's read this. He signed saying he understood this. If he had read it and understood it, he couldn't say misrep.
Isn't that always the case when you've got a misrepresentation that makes its way into the contract? You could always...
So they kind of cheated.
Yeah, but hang on. I mean, come on. The bank's got to have some protection, surely. I mean, otherwise...
Where did you used to work before you came to the bar, Paul?
Exactly. So the point is... commercial certainty, people, surely.
Yeah.
Well, So I think they cheated on the misrep point. They said, oh, the representation didn't induce. He was induced by his own assumption that he was being sold what he was told he was being sold. Kind of a bit of a cheat. But yeah, I mean, the point you're making, the interesting one, basically, they said what Paul's saying, that you're offering to contract on this basis. You are signing a representation saying, I have read, I understand, the contract says X, the contract says Y. And so the bank agreed to enter into the contract on the basis of that representation that you had read and understood it, right? So it's not really an estoppel in the strict sense. It's called a contractual estoppel. It's really more of a deeming provision, but it meant that the bank succeeded, basically for the same reasons that had failed in Low and Lumbank. And I don't know if the tension between those two have been considered. I think Springwell, Joe, you're going to talk to us about.
Yeah, so Springwell is oddly another case that concerns GKOs. Springwell bought US dollar denominated notes from JP Morgan, which were linked to GKOs, which are obviously ruble instruments. And so part of the transaction involved them also getting into foreign currency forward contracts to protect against the currency risk. But in 1998, there was a moratorium, Russian moratorium on foreign debt repayments, which had the consequence of just tanking these investments. And so there were defaults on the notes. Springwell obviously wanted to try and get its money back, or at least some of its money back. It sued JP Morgan on a number of different bases, but parts of its claims were that an employee of the bank had made misrepresentations, negligent misstatements about the riskiness of the products. The bank said you can't. Well, the bank said a number of different things, but one of the things the bank said was, we have the clauses in the contract, usual stuff, no advice, no representations, no reliance, so go away. And the course of appeal looked at this. Lord Justice Aikens gave the lead judgment, and he starts off his analysis on this part of the case by saying, well, obviously parties can agree whatever they want, but let's see if there's been any crazy cases before that have said anything contrary to that just obvious proposition. Oh, well, there is this case, Low and Lumbank, but the tricky dictum in that are obiter, so they don't need to concern us, and PK is right. So the clauses are effective, subject possibly to any statutory control of the clauses, so Unfair Contract Terms Act or the Misrepresentation Act as to reasonableness. But even there, the court said some of these clauses don't engage the statutory controls at all, because on a true analysis, they're not exclusion clauses, they're just basis clauses. They're clauses that set the basis upon which the parties are contracting.
Sorry, Joe, what does that mean exactly? Because in that case, anyway.
So what they said in that case is some of them, not all of the clauses. Some of the clauses they said they're exclusion clauses, but it's fine because they're reasonable. But others, they say they're not excluding liability. They're just setting what it is the parties have agreed, have promised to do. And so there's no liability to exclude in the first place.
So liability can never arise, because if you're agreeing, for example, I'm not giving advice, even if you have in fact given advice, you're agreeing on that basis. So the basis of your contract is no advice. So you're not then avoiding liability.
Yeah. I mean, the interesting thing about Springwell was that they didn't mention at all Smith and Bush, which is a case which might suggest there was a bit of an error in Springwell, where the question of whether something's an exclusion clause is assessed by reference to whether, but for the clause, there would be a liability. But perhaps we can come on to that later. Poonam, what happened in First Tower Trustees? Something different, I think.
Yeah, a definite change in emphasis for certain. So First Tower was 2019, and not sexy with rubles and GKOs and derivatives, something much more everyday, a lease with a clause that the tenant, in which the tenant acknowledged that the lease had been entered into without any reliance on any statements and without any representations made by the landlord. So what I call a no reliance clause. Tenant discovers loads of asbestos, so that there has to be money spent on repairing the place, and he's delayed getting in there. Now,
but the town called Asbestos in Canada recently renamed itself. I was reminded of that. Apparently they've been called Asbestos because they had an asbestos mine nearby. And they were so proud of it when asbestos was quite the thing. They named their town after it. Then they were like, oh, this is awkward. Sorry, carry on.
Anyway, back in other news, back to
asbestosis. The stuff Claudia reads is really quite extraordinary. But what the tenants in this case had read...
I just didn't want you to think your asbestos was boring compared to our GKOs.
What the tenants in this one had read was a report given to them by the landlord that specifically said that there was no asbestos and no environmental issues. So they sued the landlords, and the landlords actually quite extraordinarily even accepted that the report they'd given them as relating to this property didn't relate to this property at all. So there was no question. These were false representations that had been made, but they had the no reliance clause. So the big issue which the Court of Appeal were deciding in this case is whether the no reliance clause was, as we've touched on earlier, an exclusion clause and therefore subject to Section 3 of the Misrepresentation Act. Just to remind everyone, that section provides that a term which excludes or restricts liability for misrep is of no effect, save insofar as it's reasonable. And the way Lewison put it, Leggatt refers to the Bush case, and the way Lewison approaches the sort of question of how do you decide if something's an exclusion clause, he says, well, what would happen if the clause wasn't there? Well, if the clause wasn't there, then they would be liable for misrep. It's the clause that's making them not liable, so it's an exclusion clause. And that could have, we'll come back to that, but that's how he approached it. So he said it's an exclusion clause. Now, he then says it is a two-stage process. First question is, can the parties agree to a fictional state of affairs? The earth is flat, as Paul said earlier. And he said, yes, the parties can agree to those things, and that might give rise to a contractual estoppel. But then you have the overriding statute. And if we as English lawyers have a statute that puts controls, that's stage 2 of the inquiry. And here we do. So the contractual estoppel you might reach stage 1 doesn't work because the clause is struck down. Because if it's unreasonable, which he held that it was unreasonable. But in the way the whole case talks about things, you can see a very different emphasis from the way the Court of Appeal discussed things in Springwell. And Paul, before I hand over to you, you said it's all about commercial certainty, and I get that. But now, of course, what you've got is all these clauses that are only going to be valid insofar as they're reasonable. And I'm not sure then having to work out and advise on whether a clause is reasonable or not is very commercially certain at all. So, I mean, I agree with you. But anyway, what's happened next?
Well, look, this is the case that we're going to talk about, Trattamento, BNP Paribas and Trattamento. So very quickly, the facts. It's all about, or the background to it is something called a waste-to-energy plant, which was being built in Turin in northern Italy. I think we've got a picture of a waste-to-energy plant. There it is, beautiful thing.
Beautiful.
Alps in the background, it looks like. There you are.
Lego definitely built it.
Fantastic. So these things are not cheap. Looks
like you've drawn it, Paul.
These things are not cheap. We're talking about hundreds of millions of euros to construct these things. Anyway, Trattamento was this entity owned by, initially by the municipality of Turin. And they borrowed huge wads of cash from a syndicate of banks to build this thing. That transaction, the loan transaction, was governed by Italian law and jurisdiction, and there was a big dispute about that, and it was going on in the Italian courts. Quite separate to that, there was a parallel transaction for an interest rate swap that BNP Paribas had sold to Trattamento, and that agreement had English law and jurisdiction. And what happened was that obviously Trattamento were trying to get to attack certain things that had happened in the lead up to the transaction in the Italian courts. And BNP Paribas decided that they would try and torpedo those attempts by applying in the English courts for a whole list of declarations. I mean, there were loads of them. And so they sought negative declarations. I'll give you a couple of examples. They wanted a declaration that the defendant, that was Trattamento, was acting for its own account, had made its own independent decisions to enter into the transaction, was not relying on any communication of the claimant as investment advice, etc., etc. So obviously what they wanted to do is to get the English court to apply the law of contractual estoppel, which is fairly bank friendly, get these declarations, and they could waive it in front of an Italian judge and say, look, there you are. We didn't give any advice and we didn't induce them to enter into the transaction.
Well, can I ask you a question? Because I printed all the declarations and that's just one page of many declarations. Is it normal to have these so many detailed clauses in a contract that you act for your own account, that you have competence and expertise, blah, blah, blah? Is that normal to have so many detailed provisions?
Not a list this long, but the most of these sort of derivative financial product contracts have key clauses which confirm that no advice is being given and that there's no reliance going to be placed on it, and other sort of ancillary things like the borrower or the counterparty will undertake, so they're going to take their own advice, rely on their own advice and advisors, that sort of thing.
The sort of means they're not consumers and have like relevant expertise and stuff.
Yeah. So anyway, that's, I mean, Mrs. Justice Cockerill in BNP and Trattamento, she says, well, First Tower Trustees doesn't exclude this doctrine of contractual estoppel, and insofar as it might be taken that it could be questioning it, that's all obiter, and in the context of banking transactions, that the doctrine applies. This was an unusual case, to be fair. No evidence was called. It was simply this, some might think, tactical attempt to protect the bank's position in parallel proceedings in Italy. Anyway, we have a special guest, as I said, on the programme this week, Professor Gerald Mcneil. Let's bring the professor onto the screen. Gerald, can we get Gerald on the screen?
He's there.
Hello. Hi. Good evening.
Hi. I've frozen. Everybody's frozen?
No, we're all here.
You're all there. It's frozen on my screen anyway.
All right, you keep talking. I'll tell you when you go wrong.
I will keep talking. Gerald, now look, firstly, let me ask your view. This whole thing about basis clauses as a way of getting round the Unfair Contract Terms Act, is that still good law? Can I still argue, if I'm representing a bank, that the fact that these clauses are basis clauses means that you don't have to comply with UCTA?
I think generally no, Paul. I think PK invented contractual estoppel. Springwell really invented the idea of the basis clause, but a basis clause in most of these cases is really a disguised exemption clause. So if you apply the test that Poonam was talking about, which is it as a matter of substance an exemption clause, these clauses saying no advice, no reliance, no representations are all generally very much works of fiction in an advisory investment type relationship. There will be a few cases still at the edges where it's really a duty defining clause in a true sense. The example being given, if I hire a painter to paint my house, but we agree he's not going to paint my garages, that just defines what the obligation is. But these banking cases are a million miles from that.
But you say that, but Lord Justice Leggatt, he's the one who really attacks the basis clause, isn't it?
Yes.
In First Tower Trustees. I mean, that has to be obiter, doesn't it, in that decision? That part.
Well, no, it's a hierarchy thing, isn't there? And the point is that PK and Springwell seem to have both been decided without proper consideration of certainly Smith and Bush, and by trying to make Low and Long Bank go away unconvincingly. So when you get to the stage at which you have either an emboldened Court of Appeal or more likely the Supreme Court looking at this, they're going to have to deal with the fact that you've got 10 years of jurisprudence that ignores quite important authorities, but more importantly, the statute. The statute, as Leggatt says, embodies an important public policy that judges are there to uphold, not to try and circumvent.
So hang on a minute, Gerald. So if we're going to have, let's say you're right, these are all exclusion clauses, we're now going to look at whether they're reasonable. What do you say about the argument, which I can't remember, was it Flo? Somebody said in a Barclays Bank case that these clauses are so prevalent in all these documents, which is why I asked Paul the question I did, that they're reasonable because it's what everybody does.
Well, that's fallacious. That's the kind of argument that really can't count. I mean, Lewison makes arguments in other cases that certainty is an important factor in reasonableness. No, it's not. Parliament has said, under both Section 3(1) of the Misrep Act and Sections 2 and 3 of the Unfair Contract Terms Act, the courts have to look at these things and determine whether they're reasonable. And that's a policy choice. It belongs to Parliament, not to Her Majesty's judiciary.
But isn't the problem that if these clauses are too readily undermined, that the banks will simply refuse to lend money, and that's going to clog up the commercial lifeblood of the economy? And banks need certainty. They can't have a situation where they enter into these huge transactions, they put all their money at risk, and then later on somebody pops around and says, well, hang on a minute, there was this conversation over a drink when we signed the agreement, and the bank manager said to me X, Y, and Z. I mean, that's just not any way anybody can do business, is it?
Oh, come on, Paul. But PK was decided in 2010. You think that banks didn't lend money in all the period before the last decade? I mean, that was the period of leading up to the global financial crisis. Banks have always lent money. They've always desired as much certainty as they can to avoid losing in litigation. But it's not essential to make the economy go round.
Because fortunately, the courts have upheld the integrity of the commercial bargains that these parties have entered into. That's why the banks continue to lend money.
Banks were lending money in other countries too, though, weren't they, Paul?
But it's
right.
People like...
Talk to German lawyers, talk to Dutch lawyers as I do, and they can't believe, or German bankers and Dutch bankers, they can't believe what they get away with in London. It's just seen as being...
And that's why London is the global financial centre that it is, because we have integrity in our financial dealings. So people...
No. Let's not mix integrity with certainty. Your point is we want certainty. There's nothing integrity about it.
Yeah, I think it's very, especially given Poonam's case, right? I'll give
people like it's people like you that are causing all the trouble with these poor banks. That's what I'm saying.
People like me. Or people like Gerald?
No, Gerald. Well, you as well, Claudia. But
I'm trying to.
Let's hope so.
Look, there is a real. I'll ask you, Gerald, first, and then everybody else. There is an issue here, I suppose, in a low and long bank situation where you've got the poor young widow who buys the car, doesn't read the paperwork.
To understand the contract. That's what.
It's a hard case. I agree. It's a hard case. But is Springwell really a hard case? I mean, sophisticated. It's a Greek shipping family, wasn't it? I mean,
I've written on this quite extensively, as I think Poonam was saying earlier, and I wrote about it. And Springwell looks like the right result on the facts of that case, but it was almost reinforced by all these unnecessary extra doctrines that would apply in cases of small and medium-sized businesses rather than multimillionaire shipping families. I think those particular investors took too many risks, but other people have been sold swaps, as we know, with no clue what they were doing. Crestsign and Thornbridge being the obvious examples in the swaps context, and they've been punished. Very small family businesses for the findings in Springwell.
So, Gerald, can I ask, are you happy if we had, First Tower Trustees way of doing it, where you look at it as an exclusion clause, is it reasonable? Are you happy with that as the approach? Or do you want to get rid of contractual estoppel as a doctrine, stage one, completely in the first place?
I think contractual estoppel is just a fiction. I think Martin Morbick invented it in PK. It sort of was grabbed by very bank-friendly tribunals as a way forward. I've written extensively for 10 years saying that it really is an illegitimate development of the law of contract. It's clear that Lord Justice Leggatt thinks that, and even in the Trattamento case, the judge recognised that he might do things now in the Supreme Court. Lord Justice Lewison went away and thought about it and gave a Combar lecture this year, which I think is available quite widely, in which he began to also say he had his doubts about contractual estoppel and the documentary fundamentalism of the last 10 years of cases. So I think the wind is blowing in that direction, but it also reflects the fact that judges are now remembering that public policy is decided by Parliament on these things, not by judges.
Can I argue, if I wanted to, that the distinction, the basis clause as a way of getting out of UCTA is still good law? Can I argue that, or is that totally dead now?
Well, that is the landlord's argument in First Tower Trustees, and they sought permission from the Supreme Court as well, didn't get it. I think the basis clause is near dead unless you are in a genuine initial duty-defining context. Something tucked away in the boilerplate saying that the main obligations on page 1 don't apply on page 120 are the kinds of things that are really disguised exemption clauses.
But Gerald, sorry, can I ask you, where do you stand on other clauses that purport to restrict what you can do? I'm just trying to understand where you come on this. What about no oral modification clauses and entire agreement clauses? Would you also say that insofar as they oust people's rights and, they're in little small writing, they shouldn't be upheld? Well,
the entire agreement clauses have a very limited impact really on collateral warranties, so that they've been dealt with in cases like AXA and Campbell Martin. Separate topic is the no oral modification or restriction of waiver clauses. We've got a recent Supreme Court case on that, which is obviously MWB, which I think we're going to come on to. They're okay as long as you have a safety net. But the problem with MWB is the safety net looks like a very, very strong form of estoppel. I think we're going to come on to that. But it's Lord Sumption certainly erects the bar for getting around a no oral modification clause, puts the bar very high.
Yeah.
Okay, well, look, Gerald, thank you very much for joining us and sharing your views. We will now we'll say goodbye to Gerald.
Bye, but because you've led me very confused, I'm going to have to think now. Thank you, Gerald. Bye.
Pleasure. Bye.
Thank you.
We're going to look at a couple of case studies very quickly before we go. So we've got case study number 1, if we can put that up on the screen. So what we've got here is we've got a bank. They agree to lend Mr. and Mrs. Pauper £200,000 for a house purchase, fixed rate of interest 5%. But the bank manager advises them that rates are likely to rise to 10%. We can assume that advice is wrong and negligent. But the loan contains a clause that says, slightly different sort of clause, this one, the customer and the bank agree that all and any advice provided in connection with this transaction was both careful and accurate. So does the clause prevent the claim? Let's see if we've got any bank sympathetic contributors. Claudia, what do you think?
So I'm going to leave to one side whether they can make out that they were given advice, whether it was in fact negligent, the kind of nature of the representation. But this is this kind of idea that you're agreeing to a fiction, right? If they're saying they agree that the advice was careful and accurate, that doesn't make it careful and accurate. So if you follow Lord Diplock's reasoning and there's subsequent, there's sort of post-PK reasoning, then it's really an exclusion clause because it's excluding liability for negligence in effect, or that's what it's trying to do. So it will be subject to the requirement of reasonableness, I think, under UCTA on this new line, this sort of Leggatt line rather than the Springwell line. And then the question is whether it's reasonable, which might depend on a few other factors. And I guess I'm guessing from their name, Mr. and Mrs. Pauper, that they're the little old lady who didn't really understand the contract, and yet you might find that it's unreasonable. I guess that would depend a bit more on the facts.
Well, let's go round. Joe, what's your view?
I agree with Claudia. Yeah, it's an exclusion clause and it's almost certainly unreasonable.
And Poonam?
Yeah, I agree. You can't, by changing the wording, it's still an exclusion clause on the Leggatt.
Well, but hang on a minute. PK is still binding Court of Appeal authority. It's not been overruled. Why isn't PK authority for the proposition that you can have a basis clause like that?
But we're assuming that we're the Supreme Court here, Paul.
We're the Supreme Court, but also I think the kind of clause in PK was slightly different because he was saying PK that he read and he understood what was going on. Whereas here they're saying they agree that the advice is not negligent, which actually isn't really something they're in a position to make any representations about, right? How do they know?
This
So
is
we've got a comment here. We've got a comment here on the chat from, I won't mention the person's name in case they don't want to be mentioned, but it says, no, clear evasion of UCTA.
I do know who the person is. I'm not going to say the name either, but nice to see you're watching, and I couldn't agree more. You're absolutely right.
You're all look. I'm not going to progress because we've got another case study quickly to look at. But I mean, what's the bank supposed to do? The bank doesn't know.
Don't give negligent advice.
I would say it would be good to have Gerald on this to know what his view is. But I know he would have sided with.
I know what Gerald's going to say. Gerald is a liberal, sympathetic to customers, anti-business, anti-freedom of contract. That's, I mean, Gerald, I love him dearly, but, you know...
okay,
got to say it. Right, okay. Case study number 2. Oh, he's back.
I think he came to laugh at you and then left.
He is like a ghost that sort of comes back. Right, okay, case study number 2. Let's have a look at this. This is so we're going to look at this other topic very briefly, Rock Advertising. Bar West Bank, it's the same bank, same ill-fated customers. This time they agree to borrow £200,000 for a house purchase. The loan has a standard non-oral variation clause. After the loan documentation was signed, the bank manager, Mr. Sharp, agreed with them that the bank would increase the loan to $250,000 if they needed it. On the strength of that promise, they agreed to purchase a house for $250,000. Now, can the paupers force the bank to lend them $250,000? If you're watching on YouTube and you're signed in, chat, send us your votes, and preferably put your name and then we'll give you a mention. So get on that chat function now, or if you're very quick, you could email us, quadcast@quadrantchambers.com. Okay, let's go round again in reverse order. Poonam, what do you say?
Well, if we're keeping it on a straightforward, simple thing, did that oral chat mean that the original loan can be increased of itself to 250? No, Rock's clear that certainty bargaining powers, you've agreed you're not allowed to orally modify, you're not allowed to orally modify, subject to estoppel, maybe as Gerald mentioned, and subject, I think, collateral contract. But so does collateral contract possibly work here? What do anybody think? Joe?
Yeah, I mean, I want to say that there's a collateral contract there, a subsequent contract. I can see that I might have a bit of a consideration problem, but you don't need much, do you, these days? So I'm sure I'll be able to find it somewhere. What about you, Claudia?
Yeah, I mean, well, depends on the facts. That's what I always say to get at. It's possible that you could say they'd agreed to loan 250, and this was an offer to vary, that they would increase. So an offer to vary, and we will increase the amount lent should you decide you need it. In which case, yes, I agree with Poonam. Rock is clear in that Lord Sumption says no oral modification clauses bind. I mean, I'm not sure that his reasoning on that was super coherent. So I guess if I was the Supreme Court, I might not agree with him and say that his alleged freedom of contract basis doesn't really hold up, because he's got this whole idea that you should be held to your agreement and be bound by what you've agreed. But what he says is that your former agreement holds good for your later self, but your later self can't bind your oral self. So
hold on a minute. We've had a comment from the same person who was correct in agreeing with the three of us.
They agree with me, don't they?
Yeah, I agree with you. Collateral contract, but where's their consideration, and where would we find it from here? So we all agree that they should be able to get the extra money from the bank.
Well, I don't know. I mean,
you've gone off and bought a house based on something that a bank manager.
All right, say the bank. You've come up with one way around it. What about if you did it this way? What if the loan document said no bank manager or representative of the bank has authority to vary this contract other than signed and in writing?
Well, that's
they couldn't rely on ostensible authority, because you'd have notice that they didn't have authority, and if there's no authority, that's it. They can't.
No, because that term only relates to a variation to the written contract. It doesn't say
this is a new contract.
A new contract.
Well, all right. You said all right. You just extended to say no bank manager, any employee has any authority to lend.
Yeah, if that was in the paperwork, then you'd know there's no action authority, and you couldn't rely on it.
Well, you would have to, it would depend on what representations there were generally, wouldn't it? Just because it says that in the paperwork. If he then says, it says that, but actually, look at the wall where it says I do have authority or something like that. Look at my business card.
Like that's old wording. That was true.
Well, you can't. That wouldn't work, because you can't hold yourself out.
I got authority.
Look at my business card printed by the bank.
No, you can't hold yourself out. So anything he says has to be
printed by the bank.
Doesn't matter if you've got it in notice there. I mean, one of the things. If you didn't have Rock Advertising, you could achieve a non-oral variation clause by that route, couldn't you? By limiting agency. Anyway.
You could, I'm sorry, I've gone silent because Joe kept talking about business cards and I just kept remembering the things Claudia's printed for you and the picture of you going, call Paul and all will be fine. Sorry, my brain went away.
Before we wind up, we should bring Gerald back and just see what he, I see he's still on the call. Can we bring Gerald back? Gerald, any thoughts on these two case studies?
Oh gosh, I was just enjoying the entertainment rather than thinking hard about it. But
you've learned this program has no rules, so we've brought you back on.
I mean, I think rock advertising is. We started talking about it earlier on, but it's. I've written about this, and I think Andrew Burrows, now Lord Burrows, has written about it as well in an article.
Fellow Liverpool football fan.
Indeed,
not alone. He gets hammered for this, but he has Lord Burrows on his side in this one thing.
Yes, Lord Burrows was a footballing blue at Oxford, I think, wasn't he? As well as being a great lawyer. So he was, yeah, that's right, yeah. So, but he's written quite critically about it. I mean, again, it's okay perhaps to say, well, prima facie the entire agreement clause works, or prima facie the no oral modifications or agents of no authority to do anything clauses, they all work. But there has to be a way around that, and the work is going to have to be done by estoppel. And certainly what I wrote is that in the light of MWB, presumably getting summary judgment is going to be much easier when people raise issues about post-contractual statements and agreements or representations or indications. But it's going to be hammered out in sort of summary judgments before masters and high court judges and county court judges. And we'll need a few court of appeal cases. The important thing about MWB is that the ratio that these clauses work is the ratio. The statement by Lord Sumption about estoppel is clearly obiter dicta. He makes it clear it's obiter dicta. He's just suggesting that it should be quite a high threshold, and it's the other House of Lords case action strength. If Lord Sumption is right, to get around the no oral modification clause, you need to have the following conversation. Let's vary our contract on the golf course. Is that fine with you? Yes, that's fine. Oh, and by the way, there's a clause in the contract saying that we can't do this. Can we waive that clause as well? Yes, let's do that. So you need to prove both the actual variation and the waiver of the actual clause. Now, that's going to invite lots of perjured evidence, I think, going forward, and can't be right. So it's going to have to be wound down to, I think, an ordinary estoppel type reasoning, an ordinary type of promissory estoppel type reasoning or waiver or whatever.
There are ways around these clauses, aren't there? I mean, we've mentioned the collateral contract. I've had cases where you have to have slightly different facts, but where the party will say, well, we weren't varying the contract, but I was waiving a right or using other doctrines that can have the effect of changing the party's legal rights without it amounting to a variation.
Look, I kind of get this. People sign things without really understanding all the small print, but just through the discussion today, it terrifies me that you have all these clauses and contracts and then their effect is going to be changed and totally lose commercial certainty by things like the concept of reasonableness, estoppel, waiver. I get the sympathy that, people don't understand and they're forced to sign these things, but I'm worried that these are all the ways we're trying to get out of the written contract.
Okay, look, we're out of time, everybody. So thank you, Gerald, again for your thoughts, and we'll say goodbye to you a second time.
Thanks again.
Farewell. That leaves it for me to say that we are next week going to take a break. We won't be on air next Thursday, but we will be coming back for the last part of this season for 3 programs starting on the 19th of November. In terms of topics for those conversations, we would really like your suggestions. So please send suggestions for topics you'd like us to cover to quadcast@quadrantchambers.com. That is quadcast@quadrantchambers.com. I think that leaves it for me just to say thank you to Ben Jacobs, Fisheye Productions, for doing the live streaming. Thank you to Emily Saunderson, our long-suffering producer, who's telling us all to wind it up now. And thank you to the Quadcast team. Until next time, thank you very much. Goodbye.